Subsection 3.159. Department of Veterans Affairs assistance in developing claims. A. Definitions. For purposes of this section, the following definitions apply. 1. Competent medical evidence means evidence provided by a person who is qualified through education, training, or experience to offer medical diagnosis, statements, or opinions. Competent medical evidence may also mean statements conveying sound medical principles found in medical theses. It could also include statements contained in authoritative writings such as medical and scientific articles and research reports or analyses. Competent lay evidence means any evidence not requiring that the proponent have specialized education, training, or experience. Lay evidence is competent if it is provided by a person who has knowledge of facts or circumstances and conveys matters that can be observed and described by a lay person. 3. Let's move a little bit more here. Substantially complete application means an application containing the claimant's name, his or her relationship to the veteran, if applicable, sufficient service information for VA to verify the claimed service, if applicable, the benefit claimed and any medical conditions and or on which it is based, the claimant's signature, and in claims for non-service connected disability or death pension, and parents' dependency and indemnity compensation, a statement of income. 4. For purposes of paragraph C, 4I of this section, event means one or more incidents associated with places, types, and circumstances of service giving rise to disability. 5. Information means non-evidentiary facts such as the claimant's social security number or address, the name of the military unit of a person who served with the veteran, or the name and address of a medical care provider who may have evidence pertaining to the claim. B. VA's duty to notify claimants of necessary information or evidence. When VA receives a complete or substantially complete application for benefits, it will notify the claimant of any information and medical or lay evidence that is necessary to substantiate the claim. VA will inform the claimant which information and evidence, if any, that the statement is to provide to the VA, and which information and evidence, if any, that the VA will attempt to obtain on behalf of the claimant. VA will also request that the claimant provide any evidence in the claimant's possession that pertains to the claim. If VA does not receive the necessary information and evidence requested from the claimant within 1 year of the date of the notice, VA cannot pay or provide any benefits based on that application. If the claimant has not responded to the request within 30 days, VA may decide the claim prior to the expiration of the 1-year period based on all the information and evidence contained in the file, including information and evidence that is obtained on behalf of the claimant and any VA medical examinations or medical opinions. If VA does so, however, and the claimant subsequently provides the information and evidence within 1 year of the date of the request, VA must re-educate the claim. Authority 38 U.S. Code 5103. 2. If VA receives an incomplete application for benefits, it will notify the claimant of the information necessary to complete the application and will defer assistance until the claimant submits the information. Authority 38 U.S. Code 5102B, 5103A, 3, and several more. VA's duty to assist claimants in obtaining evidence upon receipt of a substantially complete application for benefits. VA will make reasonable efforts to help a claimant obtain evidence necessary to substantiate the claim. In addition, VA will give the assistance described in paragraphs C1, C2, and C3 to an individual attempting to reopen a finally decided claim. VA will not pay any fees charged by a custodian to provide records requested. Obtaining records not in the custody of a federal department or agency. VA will make reasonable efforts to obtain relevant records not in the custody of a federal department or agency, to include records from state or local governments, private medical care providers, current or former employers, and other non-federal governmental sources. Such reasonable efforts will generally consist of an initial request for the records, and if the records are not received, at least one follow-up request. A follow-up request is not required if a response to the initial request indicates that the records sought do not exist, or that a follow-up request for the records would be futile. If VA receives information showing the subsequent request to this or other custodian would result in obtaining the records sought, then reasonable efforts will include an initial request, and if the records are not received, at least one follow-up request to the new source, of an additional request to the original source. The claimant must cooperate fully with VA's reasonable efforts to obtain relevant records from non-federal agency or department custodians. The claimant must provide enough information to identify and locate the existing records, including the person, company, agency, or other custodians holding the records, the approximate time frame covered by the records, and in the case of medical treatment records, the condition for which treatment was provided. 2. If necessary, the claimant must authorize the release of existing records in a form acceptable to the person, company, agency, or other custodian holding the records. Authority 38 U.S. Code 5103 A, B, 2. Obtaining records in the custody of a federal department or agency, VA will make as many requests as are necessary to obtain relevant records from a federal department or agency. These records include, but are not limited to, military records, including service medical records, medical and other records from VA medical facilities, records from non-VA facilities providing examination or treatment at VA expense, and records from other federal agencies such as Social Security Administration. VA will end its efforts to obtain records from a federal department or agency only if the VA concludes that the records sought do not exist, or that further efforts to obtain those records would be futile. Cases in which VA may conclude that no further efforts are required include those in which the federal department or agency advises VA that the requested records do not exist, or the custodian does not have them. I. The claimant must cooperate fully with VA's reasonable efforts to obtain relevant records from federal agency or department custodians. If requested by VA, the claimant must provide enough information to identify and locate the existing records, including the custodian or agency holding the records, the approximate time frame covered by the records, and in the case of medical treatment records, the condition for which treatment was provided. In the case of records requested to collaborate a claimed stressful event in service, the claimant must provide information sufficient for the records custodian to conduct a search of the collaborative records. 2. If necessary, the claimant must authorize the release of existing records in a form acceptable to the custodian or agency holding the records. Authority 38 U.S. Code 5103 A, B, blah, blah, blah. 3. Obtaining records in compensation claims. In a claim for disability compensation, VA will make efforts to obtain the claimant's service medical records. If relevant to the claim, other relevant records pertaining to the claimant's active military, naval, or air service that are held or maintained by a governmental entity. VA medical records are records of examination or treatment at a non-VA facility authorized by VA, and any other relevant records held by any federal department or agency. The claimant must provide enough information to identify and locate the existing records, including the custodian or agency holding the records, the approximate time frame covered by the record, and, in the case of medical treatment records, the condition for which treatment was provided. Authority U.S. Code 5103 A, C, and on. 4. Providing medical examinations or obtaining medical opinions. 1. In a claim for disability compensation, VA will provide a medical examination or obtain a medical opinion based upon a review of the evidence of record. If VA determines it is necessary to decide the claim, a medical examination or medical opinion is necessary if the information and evidence of record does not contain sufficient competent medical evidence to decide the claim. But A. Contains competent layer of medical evidence of a current diagnosed disability or persistent or recurrent symptoms of disability. 8. Establishes that the veteran suffered an event, injury, or disease in service, or has a disease or symptoms of a disease listed in 93.309, 93.313, 93.316, and 93.317, manifesting during an applicable presumptive period, providing the claimant has the required service or triggering event to qualify for that presumption. And C. Indicates that the claimed disability or symptoms may be associated with the established event, injury, or disease in service or with another service-connected disability. To paragraph 4, could be satisfied by competent evidence showing post-service treatment for a condition or other possible association with military service. 3. Paragraph C4 applies to a claim to reopen a finally adjudicated claim only if new and material evidence is presented or secured. Authority 38 U.S. Code 5103A. D and on the circumstances where VA will refrain from or discontinue providing assistance. VA will refrain from providing assistance in obtaining evidence for a claim if the substantially complete application for benefits indicates there is no reasonable possibility that any assistance VA would provide to the claimant would substantiate the claim. VA will discontinue providing assistance in obtaining evidence for a claim if the evidence obtained indicates that there is no reasonable possibility that further assistance would substantiate the claim. Circumstances in which VA will refrain from or discontinue providing assistance and obtaining evidence include, but are not limited to, 1. The claimant's ineligibility for the benefit sought because of a lack of qualifying service, lack of veteran status, or other lack of legal eligibility. 2. Claims that are inherently incredible or clearly lack merit. And 3. An application requesting a benefit to which the claimant is not entitled as a matter of law. Authority 38 U.S. Code 5103A 2 and on E. Duty to notify the claimant of inability to obtain records. 1. If VA makes reasonable efforts to obtain relevant non-federal records but is unable to obtain them, or after continued efforts to obtain federal records concludes that it is reasonably certain they do not exist, or further efforts to obtain them would be futile, VA will provide the claimant with oral or written notice of that fact. VA will make a record of any oral notice conveyed to the claimant. For non-federal records requested, VA may provide the notice at the same time it makes its final attempt to obtain the relevant records. In either case, the notice must contain the following information. 1. The identity of the records VA was unable to obtain. 2. An explanation of the efforts VA made to obtain the records. 3. A description of any further action VA will take regarding the claim, including but not limited to notice the VA will decide the claim based on the evidence of record, unless the claimant submits the records VA was unable to obtain. And 4. A notice that the claimant is ultimately responsible for providing the evidence. 2. If VA becomes aware that the existence of relevant records before deciding the claim, VA will notify the claimant of the records and request that the claimant provide release for the records. If the claimant does not provide any necessary release of the relevant records that VA is unable to obtain, VA will request that the claimant obtain the records and provide them to VA. Authority 38 U.S. Code 5103A, B, 2, on and F. For the purpose of the notice requirements in paragraph B and E of this section, notice to the claimant means notice to the claimant or his or her fiduciary, if any, as well as to his or her representative, if any, authority U.S. Code 38, 5102B, and 5103. We're going to stop. I'm running out of breath, need a drink of water. Well, the next video we'll continue with this until we run out of these, and then we'll talk about they violated every one of them I'm going to show you, so I'll give you examples of what I've gone through. It may be the same as what you're going through. We'll take a look. So anyway, thanks. See you next time. Over and out.